all aspects of gender on having an access to the internet. According to the recent International Finance Group, the Philippines was one of the 32 nations that lost out $1 trillion in gross domestic product as a result of women's exclusion in the digital world. Under the Philippines' march toward digitalization, the gender gap in technology only gets more obvious. And this 2023, there is a need for equality and inclusivity in the field of technology, innovation, and ICT, in line with the International Women's Day theme, Digital, Innovation, and Technology for Gender Equality. According to the Philippine Commission on Women in 2023, it acknowledged that while the country is lagging digital indices due to challenges of internet connectivity, speed and reliability, it has successfully leveraged digitalization and innovation to benefit women and girls in entrepreneurship, agriculture, education, law enforcement, and preventing online gender-based violence, especially in the context of pandemic. And this is the updated General Gender Equality and Women's Empowerment Plan in 2019 to 2025. The Philippine Commission on Women identified there are two major issues relative to science, technology, and innovation, or STI, and information and communication technology, or ICT. The first one, it showed that the benefits of technology and innovation are not being fully realized or felt by women and girls. Secondly, expanded data analysis and policy research for National ICT Household Survey states that while the gender gap in the total number of people who finish ICT degrees has been minimal, the labor participation of women is just 70%, while ICT degrees is lower by 23% points compared to men, and that is 93%. This is the labor market situation for women in the Philippines. Again, this must have a further study for gender equality because we also have to include the situation of those who are member of the LGBTQIA+. And then what is our response? There are three responses by the government. The first one is the human skills. When we say human skills, it's also known as a soft skills. Allows team to work cohesively through social, creative, and critical thinking among women. And the second one is a business enabler skills. Enables individuals to connect the capabilities of digital technologies to broader business goals. That's the reason why there are so many Filipino women right now who are engaging in online selling. And the third one is digital building block skills. It leverages technology to add value and align with functional domains that are critical to the information economy. And what are my recommendations? The first one is there must be a flexible and inclusive access to technical, vocational education and training. And this refers to the skills of the women. The second, equal opportunities in the workplace. The third is a mainstreaming of gender perspective in the local government units. The fourth one, establishment of public Wi-Fi in the far-flung areas because there, even up to now, there are still barangays who cannot connect to the internet, especially the women. The fifth one, coordinate with the telecommunication companies. And the last one is to strengthen the implementation of Republic Act 11313 or Bawal Bastos Law is a gender-based sexual harassment in digital platforms because women are prone or vulnerable who are engaged in electronic commerce. And that's my presentation. Maraming salamat po. Thank you so much from the Philippines.
Thank you so much for this amazing keynote. And do we have a questions? I have a question, and Professor Maria also.
I do have a question too.
You are popular. So, Marius, you can ask the question.
Yeah, thank you so much for the presentation. And I mean, I would like to know what is the problem of the inclusion of women in the Philippine society? Is it due to your cultural background, to tradition, to religion? What is the exact cause of that? And what is the government doing in order, of course, to meet the Sustainable Development Goals? Gender equality number 5. What is concretely done, and do you think you will achieve that by 2030? Meaning you have the government has 6 years to no 7 years to achieve goal 5 of the Sustainable Development Goal.
Sir Marius, thank you so much for the question. The first question is, what happened to the Philippines? Actually, we are one of the countries who are empowering women, especially in the digital or the embracing digitalization. But why is it that women are far behind or are leaving behind? This is because Philippines is an archipelagic country. We are composed of 7,646 islands, and there is a difficulty of having an internet connection from barangay or from one island to the other. So this has nothing with the cultural background, because Philippines has been colonized with different countries. So there has no effect of the cultural aspect to the inclusion of women. It's just that the Philippines has a problem with the digitalization or even the application of the artificial intelligence is because of the far-flung barangays, and we are composed of different islands. The second question, are we able, or the Philippines can be able to achieve, especially through sustainable development goals? Well, it's not for me to say it's a yes or no, because still we are trying our best to promote empowerment among women. Because even after pandemic, we do have this digitalization. And the more we are embracing digitalization, there are more women who are prone, who are vulnerable to digitalization. Especially there are people who are bashing women, and there are also people who are body shaming women in the internet. So these are the challenges, sir, in the Philippines, sir. I hope I answered your question, po. Thank you.
Thank you so much. And now I'm happy to introduce you to the next speaker. Now we have Malaysia, Professor Siahira Abdul Shukur, that will talk about do we need laws for vulnerable people on the internet? Professor Siahira, are you here with us?
Yes. Can you hear my voice?
Yes, we can hear you. Hello, but we can't
Hello.
see you.
Okay. So I've already shared my slide.
Now we can see you.
Okay. So thank you very much, Prof. Elizaveta A. Gromova, and also the lovely lady beside her, Professor Maria A. Bazhina. I hope that I have pronounced your names correctly. It seems like I'm quite late for the session, okay, due to the topic itself, vulnerable people on the internet. First and foremost, I'd like to thank the organizer for giving me the opportunity to share my work in progress, okay, on whether we need actually laws for vulnerable on the internet. So I'm Syahira Abdul Shukur from Malaysia, from University Sains Islam Malaysia, USIM, nearby the airport KLIA. If you've been to Malaysia, okay, is in Bandar Baru Nilai. Basically, my topic will try to discuss on these three areas. Firstly, on identifying the vulnerable people, and also about computer vulnerability. And we know that there have been ethical research when you deal with these vulnerable people. So I started to explore on vulnerable people. Basically, it was my PhD research back long time ago in 2005, where I took the initiative to compare on child protection between Malaysian law and English law, since at that time, since Malaysia is a Commonwealth country, okay, and what Malaysia might learn from the English law. So if we want to look at the issue of what are the identifying vulnerable people, according to many theoreticians and practitioners, the framework of vulnerability allow us to formulate an alternative language to articulate the problem of inequality, power imbalances, and injustice. In dealing with children, it's not easy, okay, and in fact, I started to get to know my husband also through the internet. Okay, we met during the chatting in the chatting room. Okay, as we can see how vulnerable it is, the relationship developed, and human vulnerability is also to some extent present in discussion also about data protection, privacy, data-driven technologies, okay, as what has been mentioned by Kellogg in 2004. Okay, he argued that the rationale for privacy protection is precisely addressing vulnerability individuals. As what has been mentioned by the two speakers before me, okay, Prof. Marius and also Bonnie on vulnerable, and Prof. Marius on competition, okay, in the digital age. So we can realize that it comes when it deals with internet, it comes with risk. It comes also with competition. And there have been some guidelines and ethical policy call for the governance framework that recognize the situation of vulnerable groups such as women, person with disabilities, ethnic children, and consumer. So before I started my journey in 2005, to conduct research on child protection on the internet in England, I realized that what triggered me to explore this area is because the policy that has been passed by the Prime Minister of Malaysia at that time, that there will be no censorship on the internet. And that has been gazetted as a law in Section 3, Subsection 3 of the Malaysian Communication and Multimedia Act. So there have been many questions about restriction, no censorship, okay, on the internet at that time. So it triggers me to ask what happened to these vulnerable people like women, okay, person with disability, ethnic minorities, children, as well as vulnerable consumer. Okay, for example, like aging people, okay, nowadays, in order for them to order in the restaurant, they have to use the QR code in order to order food, for example. So sometimes we are not confident to use, okay, in terms of what I call the technology itself. And what inspire me to discuss is about computer vulnerability and human vulnerability. So by Professor Jonathan Harry, okay, on vulnerable adults, okay, and the law. Besides this vulnerable group, there are also specific people who are considered as vulnerable adults. And to the right of the slide is, as you can see, this is one of my publication just before the pandemic in 2020. It is about social workers and protection of vulnerable groups. As we know that there's only one ministry, okay, that going to be in charge for vulnerable people in Malaysia. Okay, so it triggers me to wonder how we're going to deal, okay, in one ministry, okay, to deal with women, okay, with disability person, okay, and I firmly believe that we need different expertise in order to deal with this different group of people. And in this book also, I explore the importance of having, okay, knowledge, okay, having experience, okay, the speech gap, okay, that we have when we communicate, okay, in order to understand this vulnerable group itself. So how we try to convince, and due to a lack of global vulnerability data, okay, answers are hard to find and risk rating is even more difficult. The loss of vulnerability are the conclusion of analyzing statistical vulnerability information over a 30-year period. And those vulnerabilities have been identified in the real world across hundreds of thousands of systems and networks. Okay, and we can see that the digital realities touch also different areas of the law. For example, privacy, risk management, corporate governance, including what type of duty of care, monitor and disclosure, breach notification, information, data security, securities regulation, law of the war, constitutional provisions, and more that can be explored in terms of what is the relationship between the digital vulnerabilities and also human vulnerabilities. And we can see that there is emerging Internet of Things law and standard enacted by the government across different countries to combat the vulnerabilities of Internet of Things. And there is a need of globalized Internet of Things law, and that the common user be made aware of the security, ethical, privacy threats imposed by modern Internet of Things devices. So I was lucky to be selected to join this unboxing digital laws in South Asia during the lockdown in year 2020. It was a virtual workshop, okay, from ASEAN countries, okay, and we were discussing for 5 days, okay, about the digital laws that should be applied in the Southeast Asia and what are the movement, okay, in order for us to understand the other continents, European countries, Russia, okay, and then New Zealand, Australia, that part of Asia Pacific. And this is thing that we believe that even though Internet, okay, there is no basically a clear jurisdiction, there is there should be coordination, okay, in terms of the working towards the issue. So ethical research with vulnerable people, even though my research is more on children and young people in using the internet, okay, about content, about communication, how online life can expose vulnerable people to range of risks. As we can see during the pandemic, okay, where we are forced to do everything online, okay, they have various of difficulties, okay, as what have been mentioned by Prof. Bonnie just now about access to the internet, okay. We also have difficulties to access to the internet. The young children to cope with online classes, and as a teacher, as lecturers, how to make our young people, okay, focus on what we are delivering. Okay, so it was like a nightmare in the beginning of the semester due to lockdown. So thus, professional needs to identify the risk, okay, and we do not know really what are the risks behind this access to the internet, okay, and we are forced to have to buy mobile phone, okay, to our children, so at least they can follow their classes online, okay, especially those who have children who are going to sit for big examination, okay, as an entrance to the university. So the issue is what are the evolving tech against the evolving risk. So the social media also become the source of risk, as we can see, okay, as well as what we can see about body shaming, okay, hate speech, okay. So this actually also and what we also have this just before the pandemic in 2020 is the issue of mental health among young people and children, okay, how the exposure to the screen, okay, has made them vulnerable itself, okay, even though they have been some people believe that the internet is the new babysitter, okay, but again, there is a risk behind if the children, especially the babies, okay, are exposed to the internet. We can see that our young parent, okay, they give their child, okay, their baby as early as 6 months, okay, to use the to watch YouTube from the iPad, for example, okay, just to make sure they are quiet, okay, they don't make noise and so on. So they are evolving risks and also evolving technology. So the question is that, do we need to protect our young children, or do we need specific law for it? So since the case of Richard Huckle, okay, a pedophile who had a British pedophile who was charged in British, okay, during his visit to Malaysia also, he managed to groom some of the children in Malaysia. Due to that case, okay, the Malaysian government has taken the initiative to come out with the Sexual Offences Against Children Act 2018, and that was the first law that tried to protect the children and young people. Okay, prevention is better than cure, and this is what basically is being learned from cases like in US as well as in UK. So during the pandemic, as what I mentioned, and it has forced us to teach and learn via the internet, vulnerable groups like children and people try to struggle to cope with the new way of teaching and learning. And in Malaysia, particularly, we have 5 semesters where it was online. Okay, we have less of face-to-face communication. Okay, it was only last 2 semesters, okay, that we bring together, okay, face-to-face, okay, as we have found that they have difficulties. Okay, some of our students, not only students, but the lecturers are also has difficulties in coping with this new online methodology. So the question remains as whether we should empower, okay, because there are many programs nowadays, okay, media literacy, okay, but how we want to protect these vulnerable people? They are people where in some reported case we find that they need interference from professional, okay, in order to make sure that they know how to pick up what is right, what is wrong when they explore the internet. So that is the question that's remain, okay, by the policymakers itself, okay, and this is what also we discussed during the ASEAN platform that we had during the pandemic COVID-19. So I believe that is all from me from Malaysia. Again, I do welcome any question. So this is our campus in Malaysia. So hopefully that we can also have a conference also next year in October. Okay, all are invited. So, and that's all from me. Thank you very much.
Thank you very much. Please, do you have questions? Well, when there is no question, I have question. Siahara, so I just, while I was listening to your report, it was very interesting, and I want to thank you because it's really enriched my knowledge of Malaysia law and the problems that you face in Malaysia. And in Russia, you see, there is I think that there is problem of children's access to internet and how to protect them, but you've also said that the category of vulnerable people includes also women. And in this case, I just have a question: why in Malaysia you state that women have such status, whether they are limited in access to internet, and is it prohibited, or how it is going on in your country? Why there is such conditions, and how it is expected to be?
Yeah, thank you very much, Kay, for the question. So in a paper that I've written 3 years ago on vulnerable on the internet for women and children, this is based on the data by Royal Police Enforcement. 97% of scam lovers, the victims are 97% are women. So there are 2 issues here. Firstly is about difficult access to the internet. But the second issue is also many Malaysian, they are an active social media, Facebook. For example, social media, Facebook, Instagram. So the issue is that there have been reported cases where these many lonely women, they have lost millions of money, okay, after being scammed online. Okay, so again, the data that we have in by the police, Royal Police Malaysia, 97% the victims are women. So regardless of the background, okay, we can find that, okay, even professional, okay, doctors, okay, they easily being scammed on the internet. So that is the question: why these people, okay, are easily be scammed on the internet. So at the moment, there have been initiative not only by the government but also by the Central Bank of Malaysia in order to curb the situation. Okay, we have quite a number of reported cases also, sadly to say. Okay, there's one reported case where a pension woman lost his pension money, her money, okay, after get to know someone on the internet. So this is something that we think that awareness, education, and so on need to be continuously done, not only by the government but also by the individual itself. So I don't know whether I've answered your question or not, but in many ways we feel that gender also become an issue because we realize that women are easily being scammed, okay, on using the internet.
I see, I understand the point. So they are more often become victims of in internet, so that is the point.
Yes.
Okay, thank you very much. And we are going further. And the next speaker, we want to invite William Managa Mokov from South Africa. And the report is The Influence of Artificial Intelligence on Africa and appraisal. William, are you here? William. Okay, but we do not hear you. We do not hear you. Just.
Okay, can you hear me now?
Yes, perfect.
Okay, I'm William Manga Mokofe from South Africa. I hold a PhD. I'm also an advocate of the High Court of South Africa, a researcher, author, and all of the above. I want to take this opportunity to thank the organizers of this wonderful conference. A special thanks to Professor Elizaveta Gromova. I will be speaking on the influence of artificial intelligence on the African continent and appraisal. I will not keep you guys too long. I will go straight to the point. So this paper explores the multifaceted impact of artificial intelligence on the African continent. As AI technologies continue to advance globally, understanding their specific implications for Africa is crucial for informed policy making and development strategies. So this paper basically examines the ways in which AI is being adopted and integrated into various sectors in Africa, including the healthcare, agriculture, education, and finance, with a focus on both opportunities and challenges. It also addresses the potential for AI to bridge socioeconomic disparities and promote inclusive growth, while also considering ethical concerns, data privacy, and regulatory frameworks. The African continent characterized by its rich diversity in cultures, languages, and levels of technological development, stands at a pivotal juncture in its relationship with AI. As nations across Africa grapple with the dual challenges of embracing technological innovation while addressing long-standing socioeconomic disparities, the role of AI becomes increasingly complex and multifaceted. Understanding how AI is being adopted, integrated, and navigated within Africa is essential to both unlock its vast potential and address potential pitfalls and inequalities. However, the discussion goes beyond mere technological adoption. This paper also delves into the ethical considerations surrounding AI in Africa, including data privacy and the need for robust regulatory frameworks. While AI has the potential to bridge socioeconomic gaps and enhance inclusivity, it is vital to tread cautiously to prevent exacerbating inequalities or compromising individuals' rights and dignity.
William, we do not hear you and your picture is stopped. Frozen. Or something
Within
else.
Africa,
Oh, yes. Continue, please.
such
No.
as health,
Now it's okay.
agriculture. Hello?
Yeah, dear William, in a second your picture, your video was frozen. Now we can see you and we can hear you, so please continue.
Oh, I'm sorry about that. This is Africa. I'm sorry about that. Okay.
Oh, we are sorry, it is Russia.
At the heart of at the heart of this paper is the examination of various sectors within Africa, such as healthcare, agriculture, education, and finance. Okay, let's look at the impact of AI on healthcare in Africa. While Africa faces unique healthcare challenges, including high disease burdens, limited resources, and access disparities, AI offers promising solutions to address these issues. AI-driven telemedicine and mobile health applications can bridge the gap between rural and urban healthcare access, offering medical consultations and advice to remote areas. AI can streamline administrative tasks, reduce paperwork, and optimize resource allocation. Hello, can you hear me?
Yes, we hear you.
Okay. AI can assist health care professionals in making more accurate and timely diagnosis, particularly for diseases like tuberculosis, HIV and AIDS, and malaria that are prevalent in Africa. AI-based predictive analytics can identify patients at high risk of developing special conditions, enabling proactive interventions and preventive measures. Let's look at some of the benefits of AI on agriculture in Africa. Remember, agriculture is a very important sector in Africa. So AI can promote sustainable farming practices by reducing environmental impacts, minimizing chemical usage, and optimizing resource allocation. AI technologies, when accessible and affordable, empower small holder farmers by providing them with actionable insights, access to markets, and opportunities to improve their livelihoods. AI enhanced weather forecasting helps farmers to adopt weather patterns and mitigate the impacts of climate change on agriculture. The benefits of AI on education in the African continent. AI can provide educational resources and opportunities to learners in remote areas with limited access to traditional schools. Personalized learning and data-driven insights can enhance the quality of education by tailoring instruction to individual needs and optimizing teaching methods. AI can support teachers by reducing administrative burdens, helping them identify students who need additional support and suggesting effective teaching strategies. AI can bridge language gaps by providing translation services, making educational content more accessible to diverse linguistics communities. And AI can promote a long life learning by offering flexible, on-demand education and training opportunities for people of all ages. Okay, so we turn to the impact of the benefits of AI in the African continent on the financial sector. AI-powered credit scoring and alternative data analysis can expand access to credit and banking services to previously disadvantaged populations, promoting financial inclusion. AI automates routine tasks, reducing operational costs for financial institutions and allowing them to serve a larger customer base. AI fraud detection and risk assessment tools enhance the security and stability of financial systems. The use of AI can lead to cost savings in compliance, customer service, and data analysis, making financial services more affordable for customers. AI fosters innovation in the financial sector, encouraging the development of new, more accessible and financial products and services. Okay, so we move beyond the financial aspects of it. We go to the ethical considerations in the African continent with regard to AI. So in Africa, where diverse languages, cultures, and demographics exist, ensuring that AI algorithms are fair and unbiased is crucial to prevent discrimination against specific groups. Many African countries lack comprehensive data protection laws or have outdated regulation that do not adequately address the challenges posed by AI and data-driven technologies. Ensuring data quality and security is challenging, especially in regions where there are limited resources. Weak cybersecurity measures can expose sensitive data to breaches and unauthorized access. Proper data protection measures and adherence to privacy regulations are essential to safeguard individuals' rights. Okay? Data privacy and regulations initiatives in Africa. Several African countries have taken steps to address data privacy concerns by enacting or proposing data protection laws and regulations. Some African countries, such as South Africa, have enacted data protection laws inspired by the European Union's GDPR, which sets stringent standards for data privacy and protection. The African Union is developing a convention of data protection and cybersecurity to create a harmonized framework for data privacy and security across the continent. Individual countries, including Nigeria, Kenya, and Ghana, have initiated efforts to draft or revise data protection laws and regulations to align with modern data privacy challenges. Okay, without keeping you long, in conclusion, the African continent stands at a pivotal moment in its AI journey, with tremendous potential to leverage these technologies for societal, economic, and developmental progress. To realize this potential while addressing ethical, regulatory, and governance challenges, the establishment of robust AI frameworks is imperative. This framework should prioritize ethical principles, data privacy, and the responsible use of AI, enabling Africa to harness the transformative power of AI while safeguarding the well-being and rights of people. Thank you very much. I'm sure I've kept it short. Thank you.
Thank you so much, dear William, for this very interesting keynote. And my question is, if you are implementing artificial intelligence to the justice system in South Africa, could you please tell us that?
Yes, the South African government started as early as 2005 to implement, come out with technological laws. For example, they come out with what they call the POPIA Act, which will protect privacy of people who are online or any information that's given online, and the ICT Act. So there are already two acts that have been enacted by the South African government to protect information and privacy and everything that goes online. Does that answer your question, ma'am?
Thank you so much, Professor.
Thank you.
And we are moving forward. Dear participants, I want kindly to ask you to follow the timing because time is precious for all of us. So I want, and again, I'm very glad and honored to give the word to my good friend and colleague from United Arab Emirates, Professor Shadi Al-Jdaifat. Shadi, are you here with us?
Dear Elizabeth, I'm here. Thank you very much for the
we can
warm
see
welcome.
you.
Can you hear me?
We can both hear you and see you.
Good, thank you. All right, well, thank you very much, first of all, and good afternoon, Your Excellencies, faculty, esteemed chairs, and the guest speakers from all around the world. I would like to first to clarify one single point before I start with my title, The Public International Law in the Digital Era. The first professor introduced his speech. He mentioned that in Islam, it's forbidden or prohibited to use, let's say, digital machines or so forth. This is a very scientific and religious thing, and I would assure you that in Islam encourage inventions and encourage development in just about every field. And if we take, for example, Jabir bin Hayyan, who actually invented the numbers, the algebra, and so forth. This was out of my paper, but I thought, to clarify it for the first speaker. First of all, I would like to say that international law is well constructed, recognized, and actually attempted the law itself since the establishment. We are talking 300-400 years ago for the customary international law, established a very solid rules. The law itself, public international law, is capable of adjust with movements around the world, adjust with technologies, and in specific in our digital era. From the rise of AI, artificial intelligence, the automation to the proliferation of the Internet of Things, until the blockchain and so forth, the public international law was actually of a contribution to such technology. What's the significance now of international law in maintaining a global order when we discuss the digital era? International law, and as everyone knows, provides a legal framework for regulating interactions between states, protecting human rights, and in the between the lines, we must admit that public international law promotes for cooperation. So if we are promoting for cooperation in public international law, then we are adjusting with any era we live in, and in specific, our digital era of today. there must be also implications and implications with public international law when it comes to the digital era. The jurisdictional and sovereignty issues in public international law, and how the law as a field can cope with such issue. Elizaveta, can you turn your microphone off, please? If possible, to turn your microphone off, Elizaveta.
We hear you. We hear you.
What is?
I know, but if possible, to turn your microphone off so it won't interrupt. Then, yeah. Now there are certain challenges in enforcement. How can I enforce the old customary public international rules and the contemporary rules of public international law in the time of today, or in the digital era? It's very complex era. It's very costly as well. If we discuss cyber attacks, if we discuss the effort to combat IP infringement of today. But I am sure, since international law is the product of states, then it is much easier for the state for the states to adopt new conventions and new international instruments to cope with any implications with this era, the digital era. There are key issues also with the copyright, key issues with how we determine the authorship when it comes to intelligence. When we discuss the AI. Now, how we do harmonization of laws, and how can we have public international law rules in this time, in our time, in this digital time. Now, all these laws we have across the countries, when the international community sits together, the states themselves, they can actually borrow from their own internal laws and transfer it backward, transfer it from the state into the international community, not the other way around, as we experienced previously in different stages of public international law. In the international agreements, I will suggest, and this is an opinion, I will suggest that the next international agreements, when the states sit together to draft a new international instrument, and this instrument will become, fortunately and hopefully, it will become a part of public international law. I suggest that in the digital era, that these instruments must also include the enforcement. You know, in this time, we can't keep public international law based on consent. I understand consent in this context, and I understand consent is just to encourage the states to participate, but in the same time, we have to have certain enforcement to these public international or to these conventions in order for the states to abide by. I don't want to take much time, and I know we have 16 speakers, but I have a recommendation, if you allow me to, we can adopt these recommendations at certain point if they work for the benefit of all of us internationally. Now, these local laws I was just mentioning a minute ago, they evolve at a fast-paced level. So we can always borrow, as I mentioned a minute ago, from these local laws to the international law instrument. We must also have to cope with all these implications with the digital era to establish a standing committee for international law reforms, a committee that would actually be an assist to the ILC, the International Law Commission, the one that was established in 1958. I would like to also recommend to engage a wide range of stakeholders, not only the states. We can also invite professors whenever we have to prepare an international instrument. We can rely on people on the field. This is a field of technology. You know, we are in an era of technology, not a traditional factories no more, not traditional industrial field anymore. I would like also to recommend the fact that developing or strengthening international laws to ensure that the laws promote digital accessibility to just about every state. And this is part of the human rights principles for every individual to actually have the right to use digital accessibility and inclusion for all citizens. In conclusion, I would like to say that this digital era has significantly reshaped the landscape of international law. As technology continues to evolve, our legal frameworks must evolve as well to address all these issues. Ladies and gentlemen, I'm very thankful to every one of you for this kind invitation. And when I accepted the honor of speaking at this conference, I pledged to fulfill our mandate to the best of our ability, focusing on those areas that will have the greatest impact on the growth and development of international law functionality in the digital era. In closing, I would like to wish all of you the best for the successful deliberations. I know it was or it's still a long day for you to go. And thank you. Thank you, Elizaveta, and thank you, everyone.
Shadi, thank you very much for your interesting report. Dear participants, do you have questions? Then I just want to ask, I think, very interesting question. Here in Russia, there is a lot of talks about digital code, and I do not know whether it is popular in United Arabic country, but I want just to find out whether it is possible from your point of view to incorporate public norms into such kind of digital code, or maybe it would be another kind of law, maybe it would be a single law on digital issues. And is it possible from your point of view, and is it useful? That is also a very important part of the question. Thank you.
Thank you very much. Actually, this is a longer question. It could be the longest question I ever received in my entire adult life. But at any point, you mentioned the fact that if we can borrow from international law to within the boundaries laws or the internal laws. I think in this specific era, when we discuss technology and digital inventions, I believe we should go the other way around. The local laws today are more updated as far as rules and compliance, so we can actually do a transformation the other way around. We transfer from the local laws to let public international law borrow from these rules. If the question was directed at certain part of your question about the United Arab Emirates and whether the state is actually working in digitalization or not, I would assure you and the audience, yes, the United Arab Emirates actually it's going actually a rocket speed into digitalizations in the governmental sector and let alone and the private sectors as well. That's one part. The last part, international, to form public international law rules and principles, it takes time. It's not a 1 or 2 days process. to gather international community, to gather the states all together and have them in a setup in a form of conference, this is a lot of work. But if it was the other way around, by let's say, selecting a quick committee from specific states and form this committee just to arrange and draft what will be an international convention for a specific issue of digitalization, that would be much easier. And thank you very much.
Thank you very much, Shadi.
You're welcome.
And we have next speaker. He is with us in person. And I want to introduce you to Professor Said Gulamov, the representative of Tashkent, another representative of Tashkent State Law University, Uzbekistan. Dear Said,
thank you.
The floor is yours.
Sorry, I prepared my presentation in Russian. I didn't know that it's necessary to speak English, but anyway, my presentation in Russian, that's why let me speak in Russian. Добрый день, уважаемые.
Good afternoon, dear colleagues. May I welcome all of you at this conference, Digital Technologies and Law, dedicated to the legal issues and artificial intelligence. We're living in a wonderful time of technological changes. Quantum computers, machine learning, all these innovations open up exciting perspectives for smart life community. Along with that, they set a lot of challenges in front of us. How to use the potential of this technology, is it ethical and responsible? How to protect the rights of people? How to balance the risks and advantages? How to work the efficient regulation that would stimulate innovations and not impede them and will interfere with these violations? That's extremely important agenda of our conference. It's my strong belief that we can only joining efforts can achieve success, bringing together philosophers, lawyers, and representatives of civil society. Let us use this unique opportunity to have this constructive dialogue and find a balanced solutions. I wish all of us productive work for the benefit of humanity. In my presentation, I want to tell about the research on development of the system of regulation of ethical principles and using of the quantum and artificial intelligence. I prepared a small video for 10 minutes that I would like kindly to play back, if you allow me.
Insight к правовому статусу
Insight to the legal
квантового
status of the
искусственного
quantum
интеллекта.
artificial intelligence.
Введение.
Introduction.
Быстро развивающиеся
The
возможности
quickly developing
квантовых
opportunities of the
вычислений и
quantum
квантового
computing
машинного
and quantum
обучения
machine learning
позволяют совершать
allow to
крупные прорывы в
improve
области
and
наук.
ensure the breakthrough
Создавая
in the
новые
different
мощные
spheres,
системы
creating new
квантового
powerful
искусственного интеллекта,
quantum artificial
возможности
intelligence systems,
которых значительно
opportunities of
превосходят
which
возможности
are
обычного
exceeding
искусственного интеллекта.
over the regular
Сочетание
AI.
растущих инноваций
The
в области
combination of different
квантовой
innovations in the
физики и
quantum physics
отсутствие
and the lack of adequate
адаптированного управления вызывает
management
тревогу,
and
связанную с
guidance
опасностью
cause certain
неконтролируемого
threats of
алгоритмического
uncontrollable
ущерба
algorithmic
предвзятости.
damage,
Нарушение конфиденциальности и угроз
violation of the
демократическим свободам
confidentiality and the violation of democratic freedoms intensified by the opportunities of the quantum artificial intelligence acting without any moral restrictions. It requires the fundamental reapproach of the traditional approaches and very responsible development of the special management. We are reassessing offering adaptive concept to specific risks and moral influence of the quantum artificial intelligence. Quantum nature of the artificial intelligence. Quantum artificial intelligence is based on the specific features of the quantum particles. Interference, mingling, and mixing. It's different from the traditional artificial intelligence limited by the statistical models. This type of intelligence actually showcases the efficiency of the human mind. It gives a lot of opportunities. The quantum artificial intelligence processes these superpositions a long time, achieving the exponential acceleration. Along with that, qubits are intermingled and correlate instantaneously at any distance. Quantum artificial intelligence is fundamentally different from traditional artificial intelligence or conventional one. None of them is ready to have the status of the legal entity. Quantum artificial intelligence can have the limited electronic personality for the limited responsibility. But human control should be there, taking into account the limitations of this technology. Quantum artificial intelligence opens a new era of the computing based on wonderful quantum principles. Wise management will allow to take advantage while minimizing the risks. The concept of the legal status through the perspective of artificial intelligence. Currently, there is a lot of debates concerning advantages, risks, and opportunities of the artificial intelligence getting the features of the legal entity, seeing the different perspectives on this problem. Some of them say that modern artificial intelligence still missing the qualities of intention, understanding, and the overall intelligence that are needed conditions for the full-fledged legal activities. Others stating for providing to the artificial intelligence at least limited or functional freedom, legal freedom, if it showcase specific ability to making autonomous decisions as a pragmatic solution, ensuring the interaction with the systems of the artificial intelligence. The data, as well as this point of view, as well as the others, are represented in Table 1. Quantum artificial intelligence, risks, regulation, and ethics. With the growth of the quantum artificial intelligence, there is a question of pervading it so limited legal entity characteristics, but not definition and very vague. The definition, it is hard to predict its behavior. And nowadays, the people, the human as an operator should take the responsibility for their activities. The further study are required in order to have this well-balanced model of distribution of the responsibility between the artificial intelligence and its creator. The goal is to create the management system for the quantum artificial intelligence, implies ensuring the safe and ethical development of the quantum artificial intelligence, and to maximize its efficiency for community, for society, and preserve the supremacy of the rights and dignity. It should support the innovations and prevent the exceeding violation of the laws. The ethical code for the artificial intelligence functions and principles. Ethical code for artificial intelligence is the set of the values, principles, and the guidelines that are intended to develop the usage of the artificial intelligence in accordance with the moral values. Major functions of the ethical code of the artificial intelligence. Fostering the ethical design, introduction of the moral values into the architecture of the systems of the artificial intelligence, protection of the human rights, prevention of the abuse of the rights, introducing special safety measures, improving the public trust and confidence in the artificial intelligence, increasing the awareness of the hiccups and unethical use of the AI, support of the moral upbringing and education. Effective codes are developed inclusively, introduced through the special supervision mechanisms. They should be based on the fundamental moral principles and should be adapted to a new technological reality. Quantum ethics is a new approach to the moral in the quantum technologies era. Quantum ethics is a new interdisciplinary area based on the quantum reality, laws, principles, effects, implications, phenomena, interpretations, theories, symmetries, some applied characters, cosmological models, philosophical issues, paradoxes, metaphors. It actually questions traditional ethical issues based on the classical Newton physics. As different from traditional physical theories, the quantum ethics recognizes fundamental discrepancies in the influence of the observer on reality. It focuses on interconnection of the context, but not on the universal values. Quantum ethics is specifically relevant for the development of humanistic principles, application of new quantum technologies, such as quantum computation and AI. It stresses the role of the co-creation, cooperation, and the guided influence. Quantum ethics opens up new horizons in the understanding of moral principles adapted to the reality of modern science. It could be contribute to humanistic regulation of quantum technologies. The major ethical principles for quantum AI. The development usage of the quantum AI should be guided by the basic ethical principles. The benefit for human usage for the improvement of life and welfare and well-being of people. Fairness and equality, equal distribution of the risks, the supremacy of the human and lack of the discrepancies. Based on the simple logic, reliability and safety, very rigid testing, confidentiality, minimizing of the risks and protection of the private data, wide socio-technical systems promotion, public transparency, control. All these principles require the creative implementation through the joint wisdom of the scientists, civil society, and citizens. Usage of the quantum AI, ethical principles for the quantum AI should be manifested in a specific guidelines and rules adapted for different spheres. Healthcare, it should play an additional supplementary role and not to substitute doctors. The guarantee of the confidentiality of the patient data and prevention of discrimination. In the transport, they require very rigorous testing of the UAV. The quite rapid return to the human control, quantum algorithms in terms of manipulation of the markets and prejudices. In state sector, it could be used for the investigation should be limited. We should check the algorithms for fairness, and such rules should be constantly renewed through the dialogue of experts and wider group of people as part of the development of the AI. Mechanisms for ensuring the ethics of the quantum AI in order to ensure that the ethical principles for quantum AI should be implemented in practice. It's important to have this comprehensive supervision, audits, meeting the standards, independent counseling, and protection of unethical projects, international technical standards and certification, legal regulation at the national and global level, information panels for the public monitoring, educational campaigns in order to ensure the awareness increase about the risks, protection of the informers that are exposing this unethical quantum behavior, assessment featuring the public opinion, rights protection to ensure the public control. Only aligned multi-level control will ensure ethical usage of the very powerful but very risky quantum artificial intelligence. Responsible management of the quantum artificial intelligence for the benefit of mankind. In the end, this research analyzed major legal and ethical aspects, require a solution for the responsible development of the quantum artificial intelligence. The solutions proposed as a provision of the limited legal nature for the quantum artificial intelligence with the preservation of the responsibility of a human operator. Ethical principles recommended and behavior guidelines as the overall supervision mechanisms. The goal is to direct artificial intelligence for the benefit of mankind, preventing the violation and abuse of rights. For that, we need to have the interdisciplinary cooperation on integration of the wisdom into the technical architecture, institutions, and its application. It has huge potential and capacity, but very severe risks. The very responsible development will define, will the quantum artificial intelligence a tool for improvement of the life of the mankind or will destroy it? We're all responsible for the usage of this powerful technology for the benefit of the mankind. Thank you very much for your attention. Thank you very much for your attention. If you allow me, I would like to say in the CIS countries, they're discussing till nowadays the law on the AI or special code. But we are lagging behind because there is a quantum artificial intelligence. And our life has never been the same, will never be the same, and we are lagging behind, we're dragging. And the CIS countries are becoming the platforms for testing the artificial intelligence solutions. Piloting, testing on the population. For example, take the Google. What you talk here, and tomorrow you'll see that in the Facebook and social networks, what you talked. And that's not the case in US, Japan, and Europe. You'll never see the case. Because they'll be immediately sued for that. They'll have to pay huge fines because they violate the privacy and a lot of laws that have been adopted there but not yet here. In developed countries like US or Europe that are aimed at protection of the personal data, each personality. And in our country, we are lagging behind. And I hope that all our conferences, it's not about the just talking about something, but about legal initiatives and adopting the laws, because we'll be always lagging behind otherwise. That was the major message I would like to convey. And taking this opportunity, I would like to thank the organizers and Elizaveta Alexandrovna, you and Eldar Ruslavich, and of course your chairman of the region, director, Professor Timiryasov, Professor Asiya Vitalina, for a very good organization of this conference. So it's the first very kind-hearted conference when people put a lot of effort of their heart and soul into the success of the conference. And if you have any questions, I'll be happy to answer them. Thank you very much.
Again, very much glad and honored to give the word to a participant, to a professor from Greece. Dear Elena, Elena, are you here with us?
Hello.
Hello.
You hear me?
Yes, we can hear you perfectly. Thank you.
Okay, great. So, dear all, I'm very happy to be here with you today. My name is Eleni Tsulia, first of all. I'm a lecturer for commercial law and also a postdoctoral researcher for law and technology based in Athens, Greece. I have been following the proceedings of the panel from the beginning, and I must admit that I'm excited with the topics invoked and the depth of the analysis. And I'm grateful for having been given the opportunity to participate, and I promise to keep it really short. Just tell me that you can hear me, that you
can hear you.
Hear me clear. Great. Okay, so I have a small PowerPoint which I would like to share. I guess it will help. It will help you to follow the presentation. So, one moment. So, my topic deals in essence with NFTs infringing third-party trademark rights. I assume everybody knows what is an NFT. A non-fungible token is a digital file registered in the blockchain. Usually, NFTs take the form of digital images or digital music files, and more generally of content which is in principle subject to IP rights. So my question is, what happens when such NFTs get transferred by their initial owner, by their designer, to new users, to other users, through a purchase agreement, for example, or a licensing agreement? What happens when they infringe third-party IP rights? What is the impact of the infringement on their supply agreement? Now, the idea to investigate these issues have been given by a recent case occupying the US courts, with relevance to a series of NFTs imitating the Birkin bag model of Hermes. The US courts have declared that NFTs which reproduce registered trademarks of physical objects without authorization infringe trademark law. As a result, the designer of the Meta Birkins has been compelled to refrain from their commercial exploitation and pay Hermes damages and transfer to Hermes any profits made by the Meta Birkins sales. Now, because I have promised to keep it short, the major implication of this case, which, by the way, would have been treated in the same manner. Excuse me? Hello?
We can hear you.
Okay, sorry, I just heard something. Okay, so the major implication of this case, which would have been treated in the same manner also in the EU legal order, is that NFTs infringing third-party trademark rights may be removed from trade and be destroyed, or at least they may remain available to their holders, but only for private use. This degrades their value. And in the case that the infringing NFTs have been sold to new users by their designer, their depreciation attributes to these users, to these end users, the new holders, claims for redress. In most legal orders, legal defects give rise to claims for contract termination and the reciprocal return of anything already delivered between the parties. However, the return of an NFT to its initial owner within the blockchain ecosystem may entail challenges, especially if the supply agreement has been executed by a smart contract. Another common claim in such cases is that of price reduction. This is also challenging. How can be estimated what is the actual decrease in the value of the crypto artwork, like a Metabergin NFT, which cannot be commercially exploited anymore because of infringing third-party IP rights? How can be estimated what is the decrease in its value? Now, a thorough analysis of these issues you will find in the coming issue of the International Journal of Law in Changing World, which is edited by Professor Gromova, and which I personally anticipate with eagerness. If I should draw a conclusion from this short presentation, is that the metaverse challenges the traditional legal system and provides fertile ground for interdisciplinary research. The legal treatment of crypto art is an issue to be set under scrutiny from both legal and IT experts because it raises law enforcement concerns. I believe that this conference will give rise to such collaborations. Thank you very much for your attention. I remain at your disposal for any questions.
Thank you so much, dear Elena. Well, we actually don't have questions. I just want to say thank you. I was happy to meet you within the NFT conference in Malta, and I'm happy to see you again too with this very interesting keynote. And I was really glad to see some purses and bags within this very serious event. Thank you so much again, and I will be really glad and honored to continue our cooperation. Thank you so much.
Me too. Bye-bye.
And now I'm very glad again and very honored to give the word to Professor Daniel Ferreira from Rio de Janeiro, Brazil. He will talk about arbitration and artificial intelligence. Professor Ferreira, are you here with us?
Yeah, I'm here. Can you see me?
We can see you. We are ready.
Good morning to everyone. Good morning from Rio de Janeiro, Brazil. Good morning to everyone in Russia. And good afternoon, good evening. I don't know where you guys are, so I'm speaking here from Rio de Janeiro. It's 10 a.m. And let me just share my screen to start my presentation here. Well, greetings from Brazil. You know, I'm Daniel Ferreira. I'm editor-in-chief of the Revista de Brazilian Journal for ADR, Alternative Dispute Resolution, which is Scopus Index. So I invite you all to publish. It's APC, no fees at all charged. And also I have the honor to be the co-editor-in-chief of the International Journal of Law in Changing World that myself and Professor Elizaveta Gromova created 2 years ago. So you're also all invited to publish there in our journal. So my topic today is a challenging topic. I'm going to speak about AI and arbitration. This is my email. If you need to contact me, please feel free. And so arbitration, what is arbitration after all? Arbitration is like a platypus. You know, there's a good professor here in Brazil, Carlos Alberto Carmona, that compares arbitration to a platypus or a duckbill. And this animal here, it's kind of a strange animal because it looks like a duck. It has a duck, nose, the same paws, similar paws, but it's not a duck actually. So this comparison is just to say that arbitration is not civil procedure. After all, because people that don't know the area think that arbitration, for example, in Brazil, that the civil procedure code applies to arbitration. It doesn't. What applies to arbitration is the arbitration rules, the institutional arbitration rules. Each institution, each ADR provider, arbitration provider has its own rules. Of course, I'm talking about an institutional arbitration. Arbitration can also happen, the proceedings can happen ad hoc, not inside an institution. That happens a lot with international arbitration mostly. So you see the challenge that I'm imposing to you here. We don't have the same rules applicable to arbitration, and that affects especially AI, because when we talk about AI, we're talking about machine learning. So to each arbitration, the procedural rules would be different. So each of the institutions would have to have its own AI, of course, working inside, to render, for example, a decision on arbitration award. So that's a good comparison to make. And one good hint to everyone in the field is the arbitration agreement, and of course, in the time that follows the arbitration agreement, the terms of reference or a procedural order from an arbitrator. But the arbitration agreement is really important because it's the clause, the provision that it's in your contract with the other party. So if you ever gonna use AI in any sense or any technology, it's really recommendable that you should put in which parts of the proceedings, in which moments of the proceedings, and how it's gonna be used in the proceedings. So if you limited the use of AI in the proceedings, it's gonna be the best choice. So you should put, if you ever choose to use AI at this moment in your arbitration proceedings, you should say exactly in your arbitration agreements where the AI is gonna be used. So there are basically two types of AI that can be used in arbitration. First, of course, the tools to assist human arbitrators and lawyers. And I'm gonna say like arbitrator analytic tools. There are judge analytic tools and arbitrator analytic tools that actually analyze how the arbitrator and how the judge, for example, decide. I recently wrote a paper with Professor Gromova about these judge analytic tools, which are widespread in the world. So there are. The thing is, when we talk about the judge, when we talk about the state courts, data is massive. So that there's a lot of data, the decisions are public, and that doesn't happen in arbitration. In arbitration, mostly decisions, it depends on the areas. They are, of course, confidential, and that's one of the commercial advantages of arbitration. Some parties choose arbitration just because arbitration is confidential. So that's a challenge, to use AI in arbitration. E-discovery, for example, what is discovery? Discovery, it's when a party and an arbitrator, of course, they deal with a bunch, a massive amount of documents, and they try to discover what's the best evidence there to use in arbitration. And using AI in e-discovery is really smart because you just ask the artificial intelligence to order and to organize the documents in the way they should be done, and of course to organize the data that is available when we're talking about discovery inside a computer. So that's a good way to use, and it's already being used in arbitration. And conflict checker, there's this area currently, especially in Brazil, it's a huge discussion here. It's about the conflict, the arbitrator's conflict. So in order to check the arbitrator background, to check if he has any conflict of interest with some parties, it's really good to use AI. Parties usually do a really deep due diligence today currently about the arbitrators, because the arbitrator is judging, is rendering a decision on sometimes on a billionaire dispute. So it's really important to check if he's green listed, just to say, as to use the expression the IDA, the International Bar Association, use. And of course, we have this too. So, using AI to help you as an arbitrator and to help you as a lawyer, it's really important, and it's being widely used in the world. So, artificial intelligence applications to replace the arbitrator. So, I'm talking here mostly about the AI arbitrator. And, currently, I can say to you, arbitration disputes, they are really complex. So, in simple disputes, for example, consumer disputes, that should be possible. But I'm one of the guys that defend arbitration just for complex disputes. If it's just copy and paste, that should have been done through arbitration. So the dispute is just small, and it's not worth it to be in arbitration, because one of the main features of arbitration is to choose the capacity that the parties have to choose a specialist in that field, and that is the arbitrator. So so in complex disputes, that shouldn't be used. So the question is arbitration resilient to AI? That's the biggest question here. Currently, is arbitration resilient to AI? I should say yes, because first of all, arbitration, the robot, the AI here, he's data hungry, so you need a massive amount of data, in order to feed this machine, in order for it to, for example, decide correctly and to have the data that it needs. And so that's not the rule in arbitration. The rule is confidentiality. And of course, there are exceptions. For example, investment arbitration. If you go to ICSID, which is the World Bank Arbitration Chamber, and it works for countries that have signed the Washington Convention of 1965. For example, Russia and Brazil haven't signed that treaty. So if we have investment arbitration with our countries, they follow the commercial arbitration discipline. So that's one thing. But most of these decisions, they are public in investment arbitration. I'm saying most because some of them are not, because they deal with national security issues. So this could be done, the data is available there. So this could be done in this area. But what about commercial arbitration? What about sports arbitration? What about all the other areas that are mostly confidential? Of course, this is being discussed in the field widely, about how confidentiality, and to what point should the proceedings should be confidential. For example, at CBMA, the Brazilian Center for Mediation and Arbitration, we just signed an MOU, an agreement with Jusmundi. Jusmundi is a website that disclose the arbitration awards, of course, in a non-identified manner. And they have a good tool, for example, that I previously told you of conflict checking. They have the arbitrators there, and you can use this tool to check the conflicts between arbitrators. And of course, the duty to disclose. If you are an AI, if the AI is an arbitrator, what's he going to disclose? Is it biased in any way? Is it going to disclose their algorithm? Are you going to be able to analyze the algorithm if it's biased or not? How are you going to tell that? You're going to have to hire a specialist, an expert, to say that if the algorithm is biased, or if the machine learning proceeding was done correctly. So that's of course another challenge that we face. So it's kind of hard to challenge the arbitrator. And of course, I brought here a Matryoshka, the famous Russian doll, and we in Brazil, just a quick joke here, but the Brazilians mistakenly call this babushka. I know it's not a babushka. We also call it mamushka, so Brazilians mixed everything. So, but this, I brought his as a symbol of cultural bias. So if you are designing an AI as an arbitrator, you have your cultural bias. And of course, we talk here about the fourth party and the fifth party. The fourth party would be the technology, and the fifth party would be the designer. So, I propose here you should, the fifth party should have a duty to disclose if you're using an AI, and to disclose all the data, and that should be, to disclose the bias. And just as an example, it's just not. This is not just a cultural bias here. I'm talking about a bias of legal tradition. For example, if you are civil law or if you're common law, and what's going to be the rule that you're going to use, the AI would use to assess the evidence? Is it going to be the Prague rules or the IBA rules? One it's more for common law, the IBA rules and the Prague rules are more related to civil law. So that makes a lot of difference. So those are the challenges that the use of AI impose currently to arbitration. And of course, I can tell you, arbitration is, of course, resilient to AI. They want a special, really complex award. Most of the awards that I see in commercial disputes have more than 100 pages. So if you compare to the judicial sentences from the state courts, they're much bigger because the arbitrators are receiving a big fee, arbitrator fee to render and to analyze that case. So that's one big difference too. So I finish my lecture here with Desiderata. It's a poem from 1927, which goes, go past them the noise and haste, and remember what peace there may be in silence. As far as possible, without surrender, be on good terms with all persons. Speak your truth quietly and clearly, and listen to others. Even the dull and the ignorant, they too have their story. So what I'm trying to say here, this poem is mostly about wisdom. AI might be intelligent, but it doesn't have the wisdom. And it's exactly the wisdom that works, the arbitrator's wisdom that works in complex cases. And so that's, the arbitrator can read between the lines. The arbitrator in a cross-examination, when he's in arbitration hearing with a witness, he can see the body language of the witness. And so that's not what the AI can currently do, unless, of course, if someday it achieves singularity, but that's not the case currently. Thank you.
Daniel, thank you very much. I thought that when I saw Matryoshka, I thought that you would bring an example with Masha and Bear, as you always say so when you hear. But to be serious, I want just to ask you a question. So you've spoke a lot about AI and arbitration, but before you come to this part, you spoke about arbitration agreement. And as we speak about digitalization, nowadays there is a very interesting question concerning electronic documentation. And my question is about, is it possible to conclude arbitration agreement as electronic document? So to use electronic signature, and how it is possible to identify the person and so on. So I understand that it is a very huge question, but maybe you can tell your experience of how you deal with this problem in Brazil. Thank you very much.
Hi, Masha. Thank you for your question. I don't see the bear there, but that's of course a good cartoon. And I remember that the cousin of Masha in the cartoon is Dasha. So, and they're both in, that's a good cartoon. But okay, let's talk about the electronic agreement. And of course, it's possible to sign an arbitration agreement through electronic signature, through digital signature. But it's always tricky, because if you're signing an arbitration agreement using electronic signature, you are talking about a smart contract and, of course, a contract of adhesion. So you are adhering to that contract. You cannot change the terms, and that's tricky, because you can always say that that contract was null, that you weren't aware of the content, that you weren't aware of the dispute resolution clause. So you can try to annul the whole arbitration proceeding, and not even begin with. So that happens in Brazil, for example, in consumer arbitration, in consumer causes, consumer disputes. The Brazilian Consumer Code says that even if the smart contract or the consumer contract, the contract of adhesion, has an arbitration clause, you can, as a consumer, you can of course opt to the arbitration, but of course, as you didn't have your say in that clause, you can go to the judicial courts and you will be accepted. The rule is, if you have an arbitration agreement, if you're not a consumer, of course, but if you go to the judicial court, they will just say, oh, you have an arbitration agreement here, I will respect the competence and competence principle, and will respect the arbitrator's power. So you have to go to arbitration here. But inside the arbitration proceeding, just so you know, we just use electronic signature. The arbitrators and everyone. Brazil has KPI, so it's really we use DocuSign usually, and so it's widely accepted. There was never some questions about it. So, but smart contracts, they are a tricky question. For example, you have the example of the game. If you go to games, to virtual games, they all have arbitration agreements mostly. So the biggest case was on the game Second Life, which you live the second life online. You built like structures and everything, and they worth money. Your possessions, your properties, virtual properties, they are worth money. And one player had his account banished, and he filed a lawsuit against the owner, and he filed it in one state, and the owner was from another state, from California. So the owner said, oh, there's an arbitration agreement here, he cannot go to the judicial court. And he said, oh, this clause wasn't clear. He was in the middle of the contract with small letters and everything. And the judicial court said, okay, but that wasn't clear. So you need to put in an annex, separate, and you as a disclaimer, so it will be valid as an arbitration agreement. And the interesting fact about this case was that the owner of the game said that he could not be sued in that state, in Pennsylvania. Actually, he was from California, and because he hadn't had contact with the person, with the claimant, and the courts and the claimant said, oh, I had contact with him. He used to lecture inside the road. I had virtual contact with him. And the court said, yeah, okay, so I consider the theory of minimum contact. You did have contact, so it's valid, the lawsuit here, in Pennsylvania. So that was interesting, just to say that they consider that the parties had a contact because they had a contact inside the virtual world. So that's, those are challenges that are imposed to us currently.
Thank you very much, Daniel. And we come to the next speaker.
And I'm glad to introduce you to Lama Anis Audi from Lebanon. Dear Lama, sorry for my Russian pronunciation.
Don't worry.
Okay, we can hear you.
Greetings all. If you hear me, I will begin. Yeah, and I'm an international expert assessor about ADR, head of legal Palestinian PLO in Lebanon. I will talk about Lebanese perspective here from the Office of the Minister of State from Administrative Reform, Lebanon Digital Transformation, National Strategy. In 2022, the ministry launched the digital transformation strategy to be ready to operate and effectively translate by 2030. And as Lebanon is embarking on its difficult path towards achieving the goal of reaching the digital economy with the development and expansion of internet networks, and the conditions that occurred during the corona pandemic period, which led to an increase in unemployment as a result of the economic collapse of some companies, and in light of the stifling economic crisis in Lebanon, the Lebanese citizens resorted to using electronic means in all fields, whether commercial as an alternative means of income, and to study about some to provide the price of transportation, which sometimes constitutes a barrier to university learning, especially in the stifling economic crisis. They also resorted to resolving some disputes related to this field in conducting negotiation sessions, mediation, and remote arbitration with individual and personal behavior of people to facilitate their own affairs through the internet to save time and without assigning the students to move to the sessions venue. This feature faces the spread and the effectiveness of the internet. The fact that Lebanon in this economic crisis is completely dependent on generators and solar energy, and the absence of electricity, and these are expensive, means that not everyone can get. Also, Lebanon suffers from a slow internet. Also, the safety aspect is still the biggest obstacle facing the internet in general and electronic arbitrator in particular, and the dangers of interference from hackers and crackers. The strategy emphasizes the principle of digital sovereignty, and that all servers and data centers in Lebanon are under Lebanese sovereignty and the sovereignty of official institutions only. The Lebanese government is the sole owner of the database, programs and services, and is under its direct management only. Information and data security and data protection, and considered among the foundations of national security, and neglecting any of them is considered a crime that must be punished by law. Finally, thanks to the Minister of Digital Development of Republic of Tatarstan and the President and for Russian, Mr. Strom, and its esteemed citizens, Kazan University, his rector, and special thanks to the colleague, Presence, and Dr. Elizaveta. Thank you. I'm ready for any question.
Dear Lama, thank you so much for your really brief but a very, very interesting question. I'm glad that we actually started cooperation recently, but I'm sure that our cooperation will be very, very fruitful. Thank you so much again.
It's my honor, and I'm very interested to be here. I'm proud. Thank you.
Thank you.
And we continue our topic on mediation, and we are glad to announce the report of Chijioki Ibekunbana. I'm sorry, but I'm at a loss to pronounce it in correct way. I will be pleased if you correct me and say it in correct way. And the topic is use of technologies in mediation, Nigerian experience. Thank you very much.
Thank you for having me. It's a pleasure to be here. I'm indeed very grateful. My name is Chijioke Nana Ibeku. I am the founder of 3C's Met Mediators, Center for Peer Mediation and Peace Building. And again, for 3C's Met Institute, 3C's Met International Institute of Mediation, Negotiation, Counseling, and Conciliation. All these firms are focused on the practice of mediation. I'm a lawyer, a certified mediator, and an author. It's indeed an honor to be in your midst today to talk about technology as it relates to mediation. First of all, about technology, it gives us room for accessibility, particularly with the prevalence of COVID. COVID turned around everything for mediation. That's when people really knew that there was indeed the very urgent cry for the place of technology. People were no longer being in places physically. Technology provided that platform for people to relate across the borders. So in other words, I can stay in Nigeria and connect with someone in Russia, someone in America, without even knowing them, and still have the practice of mediation going forward. And like I normally say, for us particularly, mediation is a feature of the law. Because sooner than later, there's a lot of paucity in cash. People who don't have enough money because of a lot of uncertainties in the world. People are, holding on to the ones they have, so they wouldn't want to waste more. So mediation is, what will indeed give room for people to resolve conflicts at next to nothing. So technology coming in and making it worthwhile is indeed very welcome idea. Like I said earlier, it has made it accessible. It has given room for convenience. I'm sitting in my office talking across miles away to you in Russia and other people across other continents. And yet, this is what technology has done. I like, to first of all, look at what technology has created and also look at the platform of what you people can also look into and see how you can partner and grow technology in the practice of mediation. So I've looked at the convenience area, efficiency. Of course, we cannot rule out the fact that technology brings about great efficiency in the practice of mediation. Things are more quickly done. People, you have a lot of issues that you can resolve immediately. You can quickly on anything you want to do. Particularly for mediation lacks what those of us in law call precedence. But technology gives that room. I could just quickly say, what did so and so say via technology? And the answer comes up. AI, artificial intelligence. It comes up and shows me the precedents that are lacking. Because that is the main problem people have, practitioners in mediation have. What do they rely on? So AI gives that room for you to have precedence in what you're going to do. Again, for privacy. We all know that how the systems, the technology has given a secured environment for people to discuss in confidence. So there's nothing taken out from there without your permission. So you have a secured environment where things are openly said unless you give somebody else the permission to say what you want to say outside. If not, that is kept within. And that is very good for the practice of mediation. That is where mediation and technology are actually come together to give a very good semblance of the practice of mediation. Because basically, as it is, mediation encourages confidentiality. So if you have the technology, giving room for that place for the environment to be secured, as we talk about anything on mediation, is very, very worthwhile. Then we do a lot of programs, like I said earlier, we do a lot of programs with the children. You can imagine the ripple effects it will have when children whose ages range from 7 to 15 begin to buy into technology, because it's giving them the accessibility. They can stay in Nigeria, in the remotest part of Nigeria, and have access to people in the US, or have access, if we are available, have access to someone in Russia, and yet learn of them what is happening there and juxtapose it with what is happening in the environment. And these are children ranging from the ages of 7 to 15. So technology has actually brought a very positive development, not only in the lives of these children, even in the lives of those of us who tend to facilitate those sessions. So it has made it easier for us to know what is happening, create precedents for the practice of mediation. Again, technology, as it is, mediation is all about emotion. It's all about emotion. It's one of the key components in the practice of mediation is emotion. Technology has given room via AI, artificial intelligence. You can begin to, decipher the non-verbal attitude of a human being via AI. This wouldn't have been possible. So, when you have all these things and you're on top of your game as regards emotion, then you're doing very well in mediation sessions. So that's why AI is very, very key. Again, technology also has given room for the document automation. You see a lot of things that happen. The technology has come, made it speedier. The human touch might not be as speedy as, particularly when you want to get to settlement agreements. But with the age of technology, just opposing two things, just a punch on whatever technological device you have, you could relate it to what is presently happening. And this has given room. And because Africa, for instance, all the glitches will suffer. I could be talking to you and I could be knocked off the network. So that's one of the challenges we have. Again, another challenge you have, as it is now, we have talked about the glitches. Like I said, you could be talking now and be knocked off the network. again, in Nigeria, we do not have enough of this technology, enough of these devices for the children. If the children were to have enough of devices like the computers, the whatnots, all devices, there will be more depth technologically, in addition to the practice of mediation. So mediation plays a very key role, but we have challenges. Of course, we already know about power supply. That is already a notorious fact, like you say in law. You already know about that. You know about, like I said, about glitches now. I could be saying that I've been knocked out. So, but these are only challenges. But we can overcome these challenges if your institution or your university pays attention and says, okay, we want to collaborate. We already have the pool, we have the platform, we have children, we have women who we reach out to, who are willing, to continually make the world a better place. So you can imagine if they buy into a device, if they buy into technology, as technology has offered the platform via AI, artificial intelligence, you and I can only imagine the positive ripple effects it will bring about. Yes, we have challenges, but these challenges can be overcome. As it is presently, Nigeria is doing all it can to ensure that there is no cyberbullying, they won't easily make it accessible for you to hack into someone's system. If you do that, that's an offense. So they've created a platform for people to thrive, allow technology to take its place, rule in the affairs or in different spheres of human endeavors, as it is with our mediation. It has given us a lot of advantages. We can, easily secure precedents. It has given us advantages as regards accessibility, the convenience to talk, and whatnot. So this is just basically, I don't want to take your time, but like I said, we have the platform for you. If it meets you very well, we have the pool, the human resource. You can imagine marrying the human resource and the AI via your platform, what the world will be if we can marry these two things together. Thank you very much for having me. I'm indeed grateful.
Thank you so much. It was really, really interesting. And also, I hope we will cooperate in the future, maybe organize some events together. Thank you so much.
Thank you for it. Thank you very much. I'm grateful.
Thank you. And now I want to give a word to Professor Chiara Gallese Nobile. Dear Chiara, are you here with us?
Yes, can you hear me?
Buongiorno.
Buongiorno.
Yes, we can hear you and we can see you. You look great. So please.
Then I can try to share my screen with the PowerPoint.
Yes, you can.
Yeah, but
No, you can't.
I don't know why, but it's not. Let me check. Okay, now I see it. Can you see it in the screen?
Yes, we can.
Okay, great. Should be full screen now. So thank you very much for inviting me today. I'm very glad to see you, Elisabetta, but also our colleagues. Some of them I see for the first time, some I have already seen. So thank you very much. I will try to be very short. Today I will take the opportunity to present my latest project. It's called Datacom and it's financed by the European Commission. It's about a new framework for the ethical reuse of health data. So the project has started at the beginning of July in Turin. It aims to build a new framework to facilitate the reuse of health data by the public agencies, public bodies in the European Union in an ethical way. I will develop a new theory, testing it in practical environments with two secondments, and I will focus on 3 member states, so Italy, Spain, and the Netherlands. But why did I submit this project? Why is this project now relevant and important for the European Union in particular? Because first of all, the European Union, as you may know, has now proposed a new regulation regarding the digital health data space. So it's called the European Health Data Space, with the creation of electronic health records across the European Union, and with the possibility of reusing this data for various purposes, for example, AI training, and epidemiology or research, a wide number of options. But what is the real problem? First, health data is considered a particular case of personal data, so it's considered particularly sensitive. But then, when health data is anonymized, it's not covered by the data protection law anymore, because GDPR does not cover anonymized data. However, we have known from previous research that even anonymized data is of high risk of re-identification and exploitation by data brokers. So there were many research on this topic, and I will explore it in Barcelona with Prof. Fornet. But also, we have seen that increasing number of data brokers that would sell the data, health data, de-identified, especially in the United States, in Canada, and in general, I think it's a widespread phenomenon. So it's really important to find a way to empower patients to have control over their own data, and to instruct public governmental agencies and employees of public institutions to safely handle data and to reuse it in an ethical framework. So I will develop this new framework by examining the existing literature in the 3 member states. I will also interview and make surveys to professional researchers, patients, and public workers. And I will also test the new framework in a practical environment through a focus group and a short stay in local public health agency. I will also disseminate my findings, in particular to public employees, and trying to see if my guidance, if my theory is effective. So if these people that are handling data every day are interested in knowing how to take into consideration the point of view of the relevant stakeholders, and if they know how to reuse data in an ethical and safe way. Once the project is completed, then it could be useful in very different domains, such as ethics, data protection, and data science. It will be useful for researchers, for data scientists, and it would be a starting point to open new research lines. It would also have an impact on the society, because, as I said, there is this new European health data space. And I hope it will help vulnerable groups, such as, for example, patients, to understand the importance of having control over their data and to be heard by public institutions, so that public institutions do not take detrimental decisions for patients based on their health data. And it will be also important for practitioners working in AI. So thank you very much for your attention. If you have any question, I'm here, and you can also write an email to me. I hope you think that my project is interested, and I am also open to collaboration if you are into this particular research topic. So feel free to write to me. Thank you very much.
Thank you very much, dear Chiara, for, as usual, perfect presentation, for perfect keynote. And dear colleague, Professor Chiara just offered you to cooperate, and I only can recommend you to to agree and cooperate, because she's really amazing. Thank you so much, dear Chiara.
Thank you, Elisaveta.
And now I'm happy to give the word to my colleague from Bulgaria. Dear Girgana, are you here with us?
Hello, everyone. Do you hear me well?
Yes, yes, we can hear you and we can see you.
Okay, could you please give me permission to share my presentation?
Sure.
I think I have it. Let me see. Okay, do you see it?
Not for now.
Okay, let's see. And I think now it's on screen, yes?
No. Sorry, let's wait a bit, maybe some problems with the connection.
Well, that's some technical issues.
It is crazy Russian connection, sorry.
No. Okay, I'll try once again. But okay,
yes, we have it.
To share it right now, but let me ask you questions, our colleagues. What is the first thing that comes to your mind when you hear the word document? Just think about this, and please, if you would like to share your thoughts till I'm trying to share my screen. Okay. Is it okay now?
Yes, perfect.
Oh, finally. Okay, so could you please share what is the first thing that you imagine when you hear the word document?
Something on the paper. something printed on the paper.
Yes. And do you know what I imagine?
No, please share.
Yes, usually digital files, digital content, and you will understand now why. So another provocative question: can an audio file be considered as an electronic document? What do you think?
I guess so.
Yes, correct. This
Thank
is
you.
because of the EU regulation, which I will talking about. So let me see how my presentation will start. Is it frozen?
We can see your very beautiful picture and the question, who is speaking?
Okay, and now do you see the next one?
Another beautiful picture. Yes, we can see it.
Okay, so my name is Girgana Varbanova, and I would like to thank to Professor Gromova for this amazing opportunity to present my keynote to these amazing colleagues today. So European legislation in recent years has tried to catch up with the technology progress and to regulate relationships that arise, developing and terminate in electronic environment. One of the most important acts in the EU law is a regulation 910/2040, which we usually called eIDAS. This regulation is focused on electronic documents, different types of electronic signatures, and qualified trust service. So what is electronic document according the regulation? So EIDAS define it as electronic documents. Any content stored in electronic form, in particular text, sound, visual or audiovisual recording. It should be in mind that the definition of the electronic document given in the regulation is not exhaustive. This means that electronic document is any content in the digital form, even outside the regulation definition. Thus, a technology that has not yet arisen may also in time qualify as an electronic document, as long as the electronic document is relevant to the law. So, for example, if Professor Gromova and I make an appointment for a coffee and we make this appointment in Messenger, it will be not an electronic document because no legal consequences will arise from our appointment for a coffee. But if I order her new book and make a transaction via electronic payment system, then we have electronic document, a contract of sale, even if this contract is made in a messenger. The electronic documents has the same evidentiary value as the ordinary written document. The cited norm, which you see on my presentation, provides that the probative value of the electronic document cannot be denied just because of the fact that it is in electronic form. And this, in turn, provides security in relations to the cross-border transaction. The regulation particularly obliges all the EU member states to recognize validity of electronic documents as suitable evidence in judicial proceeding. The regulation have direct effect, which means that there is no need to be transposed in the national legislation of the EU member states. So, as we see, we already know what is the classic document, which means this one on the paper. We already know what is electronic document according to the regulation, but there are some significant differences between a document created on a paper and a document existing in a digital form. In the slide, you could see a paper document as electronic document and the difference which are between them. So the written document physical and its physical properties do not change and reflect the will as expressed. For example, if we edit or making strikes on the document, this is usually visible and you could see it with the naked eye. For that reason, we say it's visible for us. With the electronic documents, there is something different. The statement, which is in electronic form, first could be manipulated, and this change may not be noticed. And in certain cases, it is even impossible to establish that there is an external intervention of the electronic document. Another difference is of the way you make a copy of the document. For the convenient paper document, when you make a copy, you have one original and relevant corresponding copies of the original. For electronic documents, we could say that electronic document lives in many originals, because when you make copy and paste, you just replicating bit by bit the data. So you have absolutely identical electronic documents. So we could say that electronic documents is living in many originals, and that's the reason it's much harder to destroy electronic document than paper one. You could burn it, just throw it, and it's not the case with the electronic document. One, you have it in the digital world, it's very difficult to erase it. So now we spoke about the electronic documents, but as with the written document and as with the electronic ones, the question is who is the author of the will. We know that the signature is a sign of authorship, but establishing the author of an electronic document presents a number of challenges. Usually, the person who is signing the documents have the subjective intention to sign it, the given document, and with signing, he or she agrees for the consequences who will arise after this physical act. On the objective side, the signature is characterized by the fact that it is handwriting, usually with letters and characters, representing a physical act of a person from whom it originates. It's unique knowledge how you draw handwriting your signature. So the function of the signature is not only to identify the author, but also to confirm the will for the occurring on the desired consequences as a result of signing the relevant document. Unlike handwriting signature, electronic signatures reveal some essential features. And with it, the natural person who uses electronic signature intends to sign the correspondent electronic document. The person possesses animus signandi, which means that the person agrees with the consequences which will occur from act of signing. Electronic signature as a way of signing a document digitally without the need of physical paper and handwriting signature. They work by mathematics algorithm to create a unique digital signature that can be verified by the others. The main, aim from the regulation is that it defines what electronic signature is. So you see on the slide the definition which is given by the regulation, Article 3, Paragraph 10, which defines the electronic signature as a data in electronic form, which is attached or logically associated with other data in electronic form and which is used by the signatory to sign. Please note that signatory means author of an electronic signature, and the author could be only natural physical person who creates the electronic signature. The regulation itself does not allow a legal entity to be a signatory of electronic signature. For legal entities, you have electronic seal, which could be issued. There are three types of electronic signature: simple, advanced, and qualified. And the main difference between these three types of electronic signature is the level of security that they provide. Simple electronic signatures have really basic low authentication. Advanced electronic signatures requires strong authentication, such as special knowledge and technical tools. It could be password, PIN code, and even biometrical data. And also it could be some tools as your credit card. every time when you make a transaction with your credit card, actually you're signing with advanced signature. And the qualified electronic signature requires a high level of authentication, which is including a digital certificate issued by a third party. It's a quality trusted service provider. The other main difference between these three types of electronic signature is that only qualified electronic signature has the equivalent, legal equivalent of the handwriting signature. For the simple and advanced electronic signature, they are not equal to a handwriting one, but this depends on the will of the parties. So if they agree, they could acquire such a legal value to the simple and advanced electronic signature, and they could be considered as handwriting. This could be in a contract, but this could be also in conclusionary actions of the parties, which means exchanging of electronic correspondence, even SMS or messenger, for example. The will of the parties is authoritatively in assigning what legal value they have given to the simple or advanced electronic signature. At the end, after my keynote presentation, please tell me, what do you think? Is it handwriting or is it electronic signature? And if it's electronic signature, what type of it?
Dear Girgana, we are feeling a bit like students. Thank you so much for this interaction. So for me, it is an electronic signature.
Yes, you're absolutely correct. It's simple electronic signature. So, could you please, may I tell you something? Just we'll go back to the question, could it be an arbitration agreement in electronic form? According to the regulation, yes, it could be. It must be signed with qualified electronic signature. And as an arbitrator in our arbitration court, I could assure you that we accept all kinds of electronic evidences, including electronic documents, and we use video conference for our hearings in the arbitration procedures.
Yeah, thank you so much for this comment. And dear Girgana, thank you so much again for this amazing keynote, for your very nice voice and for your interaction with us. We are really enjoying this. Thank you so much again. Hope for further cooperation.
Thank you very much for the invitation and for this amazing opportunity. If you would like, you could share my presentation with our colleagues. It will be a pleasure to discuss with them electronic documents and electronic signatures.
Sure, we will share. Thank you. And now I want to give the word to Professor Huma Sodher. Dear Huma, are you here with us?
Yes, I am with you.
Perfect. We can hear you. Now we can see you. Nice to meet you, at least online. Hope in person one day.
Definitely. I'm also looking forward to meeting you all, and particularly you. Thank you once again for the invitation and giving me the opportunity to share my views and my concerns regarding the legal and regulatory framework pertaining to AI. So before I share my comments and my views on the topic, let me introduce myself. I am Dr. Huma Soter. I am a multi-jurisdictional legal and regulatory professional, and I practice both in England and Wales and in Pakistan. My main areas of focus and practice and research are fraud, cross-border financial crimes, and commercial litigation, Islamic finance, and of course, artificial intelligence. I've been a Harvard University Research Fellow, and I have also been, because I can see some fellows here from Malaysia and UAE as well. So I also have been a research fellow with Malaysian ISRA, which was a sister concern of Bank Negara Malaysia, their central bank. Going back to the topic. So if we think about the topic, which is legal and laws and regulations surrounding AI, I think this is one of the most important and key areas to be considered. Yes, we are excited about different options and opportunities AI offers us and new ways of working with AI. But at the same time, if we really want to use it, deploy it, and develop it responsibility, it has to be regulated as well. So artificial intelligence, it has significant legal and regulatory implications across the globe. It presents both opportunities and challenges that lawmakers and regulators, they should address if these technologies are to be used responsibly and for the benefit of masses, as opposed to giving rise to undesired outcomes, such as, for instance, we had an interesting presentation on its effect on vulnerable people, for instance, on women, for instance, on children. And we have also seen undesired and unwanted use or abuse of data, for instance, which has been shared in context of or to the health service providers, because for instance, it was not covered GDPR. So this is one thing. But when we're
dear Huma, we can't hear you. Maybe there are some problems with your microphone.
Can you hear me now?
Yes, finally. Thank you so much.
Oh my God, see. Okay. So have you haven't heard anything until now?
Well, we lost the sound only literally for 2 seconds, so.
Oh, right. Okay. Right.
So please continue.
I was saying, so we need to critically, when we're talking about laws and regulations, what do we need to do? We need to, there's a notion, commonplace notion, that light touch regulations are pro-innovation. Whereas if a regulation or law is robust, then it has to be an impediment, or it would actually block the way to the innovation. But that notion needs to be critically examined when we are struggling and grappling with the issue of developing laws and regulation to regulate AI. So this is first and the foremost thing I would discuss, and I would actually leave it with our learned speakers as well and participants, because this is an area which needs to be researched, particularly when we look at the regulations across the globe, particularly those which pertain to AI, blockchain, and innovative technologies. So mostly they are guidelines, and mostly they are, I would say, guidance and things like that, as opposed to to laws. There are two reasons. One is we still ourselves are exploring new technologies. We are still getting accustomed to, let's say, ChatGPT and other kind of technologies. Maybe it's used in arbitration, it's used in health, and the corresponding undesired outcomes for which law is put into place. Courts are involved to adjudicate the disputes. Arbitrators are called upon to adjudicate those differences and those disputes. So this is these are the two reasons why these regulations are they are in soft form as opposed to in a form which is the ideal form, a robust regulation. I will actually discuss a few key areas which require the promulgation of laws and regulations, and where we can see in developed jurisdictions such as European Union countries, including France, UK, and countries such as Australia, United States, China, Singapore. I mean, different countries, they have issued various forms of regulations and laws. But interestingly, it is really interesting to see that we will come across various case laws. So we will see that. So first notion I discussed, it was light touch regulation versus robust regulation. And the second concept I would like to share, and I would like all of us to think about, particularly in context of laws and regulations surrounding and relating to AI, is proactive approach or responsive approach. So most of the case laws, so let me discuss one by one a few case laws. So we can see that the regulation was promulgated in response to that leading case law. These leading case laws demonstrate AI related issues which often intersect with broader legal concepts such as data privacy, antitrust or competition, biasness, data biasness and fairness, etc. And courts and regulatory bodies, both of them, and even the industry, they are grappling with how to adapt existing laws or dispense justice and create and develop new regulations. So one of the first and the foremost area which I will discuss, which of course has already been discussed and touched upon, is data privacy and data protection. And when we are talking about data privacy and protection, just now our colleague was mentioning and describing her health-related project and GDPR, and how GDPR does not cover some of those areas. So yes, GDPR is one of the regulations it covers. It comes to in our mind, particularly when we're thinking in context of European Union. But another case law which comes to our mind and which should actually give us food for thought when we are in our respective jurisdictions thinking of developing case laws, which was 2018 case of United States versus Microsoft, when the US government sought access to data stored in Ireland. So actually, it is now not only these regulations, this is not only a national issue, rather globally, the legislators and politicians, they need to sit down together and they need to think about it, because when we are dealing with the AI, so cases like United States versus Microsoft, when they were trying to access their data stored in Microsoft servers in Ireland. So these kind of cases, they raise questions about jurisdictions and data privacy, and I mean, to what extent I would say sovereigns would be able to exercise their own laws, and to what extent international laws are to be invoked. And second area is of liability and accountability. And when we are talking about liability and accountability, and particularly in context of Tesla autopilot cars and vehicles. So issues like when we are determining liability for AI-generated actions or decisions, this kind of determination of liability, it can be very complex because when we are trying to establish the responsibility, who did the wrong? So whether it is with the developer or with the person who was doing the coding, or the operators, or the manufacturers, or the AI itself. And I think just in April 2023, the Tesla Autopilot lawsuits are still ongoing and pending in US courts in particular. And I think in April 2023, now one of the car crash that happened in 2019, Tesla, they won that case. So these are the new areas because, as I said, in some of the areas, unfortunately, the legislation will be responsive, and this is one of those: liability and accountability. Whether when we are talking about Tesla Autopilot suits or car crash involving or accident involving semi-autonomous driving technology, and when we are trying to fix the liability, who is going to pay? And then the stakeholders will be definitely insurance companies, those autopilot vehicle such as Tesla company, and also the users themselves. Third area which needs to be looked at, and which was pointed out, I would say, very explicitly way back in 2016, when there was this famous and leading case of Wisconsin versus Loomis. So it was a case where the algorithms, there was a inbuilt inherent bias in the algorithm, which was used to predict a defendant's likelihood of committing a future crimes. What happened once, for example, whatever is jury's decision, and when you are sentencing, when you are actually calculating or announcing the sentence for that particular crime, for the same crime, a person who was, say, for instance, black, and the person
Dear
who was
Huma,
white,
dear Huma, I'm so sorry, but we are in a lack of time. So could you please be brief, please?
Yeah.
Thank you.
Okay.
Thank you.
So it is Wisconsin and Loomis, and then for intellectual property, again, copyright issues, they have already been discussed. I wanted to share a case law in that regard as well. And most importantly, the ethical side of AI, that needs to be covered as well. And we can see the efforts which are being made by the industry groups themselves, such as PAI Group, and the ethical initiatives taken by the governments, because they themselves, each of the government, you will see either they have an IT policy, technology policy, or AI ethic policy, or maybe the guidelines. So you'll see in one way or the other way, governments, they are also doing it. And the industry is also making efforts in this regard. What do we need to do if I am, last but not the least, if I leave all these issues, but I will definitely like to see something about those gig economy workers, when they are, particularly the way they are being, their rights are being deserved and they are being exploited. This is also an area that needs to be researched and that needs to be highlighted and explored, and particularly as researchers. That's it. There's a lot I can talk about. I also actually brought a list of few laws across the globe from different jurisdictions. But in the end, I would say, because AI is continuously evolving. Yes, we are in some ways we have to be responsive, but we have to be proactive as well, and we need to join hands. We need to collaborate together, because when there would be issues like, for instance, Microsoft US is trying to access its data from servers based in Ireland. So there will be issues like that. So for those issues, the governments, global stakeholders, they have to sit together, they have to join hands, and they have to make coordinated efforts to balance innovation, accountability, and society well-being. Thank you. Thank you very much.
Thank you so much, dear Huma. I'm finally glad at least to see you online. So hope in person one day. Thank you so much. And dear Irma, are you here with us? Okay, so dear Pablo Banquio from Argentina. Hola, are you with us?
Hello, hola.
Hola.
Yes, here I am. Good afternoon to you, Elisabetta.
Good afternoon.
Good morning. In the south of the world here with the Springs and the professor of Paraguay, Vivian Lopez, and
Yes.
the college from Brazil. Thank you. Good afternoon for all of you. At the first time, give the thank to you and to the organization, especially to Elisabetta and the Journal of Digital Technologies and Law for this kind invitation. I can't speak Russian, so I want to apologize all the college. But for 5 years, my father finishes the basic cycle of the Russian language here in Argentina, in the Anton Chekhov Institute, reading Pushkin, but it's not my case. So apologize again, and I am going to speak in English. In comparison with Russian or Portuguese, Italian is a different language, but become a universal language as I used today for give my exposition. So thanking once again to you, Elisabetta, the beautiful city of Kazan, the organization and the previous speakers, and all of you. I begin my presentation, share the screen about a legal framework for artificial intelligence. I am not done a word as in Russia and in many countries, as the brilliant professor explained before me. There are interesting initiatives on the matter. By my investigation, my theoretical investigation, refer to the situation we are experiencing in Latin America and in law in general terms. That I share my screen here. All of you talked about reality. I talk about theory, but at the times I put my clock on time and I start. This is an investigation about made in the postdoctoral in the last year in Italy, and with published a book in Spanish. As you say, artificial intelligence is being developed intensively, and we are participating in the global incorporation into our life of a lot of virtual assistants, computers, and all type of application to facilitate our activities, our daily activities. At the same time, there is a global problem of almost total absence of mandatory regulation in the both aspect, legal and technical, of the foundation, but also of the condition of the development, the operation, the control of all application of artificial intelligence technologies. So I have a theory proposed an innovative legal response that gives to artificial intelligence system a special form of personality, what we call electronic personality, and grants a certain status a legal subject, cyber subject, what we call, depending the various factor and the scope of application of each system, which is the current situation. In the era of small data, all our digital tools were based on accuracy. But now, in the era of the big data, change the way we live and interact with the technology. Because big data is imprecise, varies in quality, and is distributed around in a lot of countless servers around the world. With all this information, the robots, the robot with artificial intelligence, operate through algorithms and have a certain degree of autonomy in their operation, and also have the capacity to cause physical harm in this operation, which are the present complication that we must analyze from the point of view of law. The first problem is the robots with artificial intelligence have two characteristics. They are at the same time object and subject in the law, and it's not yet possible to classify this technology as one or another. In the second case, to be intelligent agents, they must be able to act in negotiations when entering contracts, behave responsibly for their actions in the exercise of the functions, and operate as right holders in relation with the database and content that they have created. The second problem that point the view of law is the diversity of classification. But currently, in general, are two classifications: symbolic intelligence, the algorithm with a set of specific logical instruction produce specific expert system. In mostly no problems for regulate this symbolic artificial intelligence. But the connection is what is now as machine learning, which a process that use concept not only of technology, for example, with statistics, brain modeling, psychological modeling, adaptive control theory, etc. The quantum computer, for example, can read the odd 0 and the 1 in both states at the same time. The qubits, not the bits. The third problem, in the point of view of law, is a definition problem. But we can say, within a large quantity, that the main ways of defining artificial intelligence are based in a comparison between the typical human mind and typical artificial intelligence. Three reasons, a lot of reasons, but the principles by the structure, because modeling the function of the human brain, by performance, the cognitive perception properties, the capacity to solve problems, for example, and the function, search, reasoning, planning, learning, solving problems, etc. That said, we are the challenges toward electronic personality. My thesis for my investigation is that robots with artificial intelligence would be cyber subject if they perform humanoid actions in the course of the relationship with traditional subject. Then, if the action of traditional subjects, physical or legal subject, in such a relationship are subject of legal regulation, I would be logical to assume that the other party is also a subject of the legal relationship. Therefore, ergo, I must be given with a personality that we call electronic to distinguish from the traditional, natural, and legal person. In brief, quodera demonstrandum, at its mean recognizing the need for serious reform of the law as we know it. What is my final research response in this investigation? That artificial intelligence may be artificial intelligence have a special personality with a particular status. One status universal, because they are the same problems in India, Russia, Brazil, Argentina, Paraguay, Union Europea. Universal. And total for the technologies as anticipatory by law and not by technology or economics. This universal legislation is legal, the legal foundation, and the technical of the fundaments and the condition of the development, launch, operation, and integration in other system. One regulation, universal, and another regulation directed at regulating the specific artificial intelligence systems currently created, and the law is behind of the technology and the economical result. There are a lot of legislation about this problem. The Council of Europa, Russia was unfortunately part of that. There are a lot of proposition. The European Union have a new legislation in August, in recently August, and a lot of recommendation of soft law. G8, Russia is part, Argentina, G20, Argentina, Brazil, Mexico, and Russia. The other recommendation, a lot of ISO technical standards and the asylum principles, but are only soft law, no mandatory regulation. And with this, with what theoretical structure do we support as my theory? With the theory of legal platform for unfinished author, Kurki, that he said that a legal platform is a complex property consisting in distinct elements and, like property, is often analyzed as a set of rights and divides the elements into two groups that constitutes legal platform, active and passive. For example, the minors are endowed only with the passive elements, but as the senior with discernment, intention, and full freedom, without a bias of the will, are endowed but two platforms, active and passive elements. In conclusion, for this brief presentation, we postulate the need to rethink the traditional categories of general theory of law to treat new technologies and provide a legal response that conceptualizes artificial intelligence system as special form of personality, electronic, we call, and grants its a certain condition of legal subject, cyber subject, depending, of course, of the various factor and the scope of the application of each system. All of you talked about reality, but I talk about theory. In my theory, the development of a sui generis legal regimen for the result of artificial intelligence technology. It requires a normative regulation with, I said, a universal and total anticipatory nature that identifies the place of new technology in the law. Universal for the situation in all the world, and the law because the law is behind the technology and the economy, and using the theoretical analysis that we formulate in this support the legal theory of platform possibilities. In this case, it's a possible alternative to the doctrinal concept of the cyber subject, or we call electronic personality. Thank you very much for your time in this brief exposition, and thank you again to Elisaveta Gromova and all of you, the organization and the city of Kazan, as the beautiful country is Russia for us. Thank you very much.
Thank you very much. Спасибо. Gracias.
Спасибо. Gracias.
Gracias, dear Pablo. It was, as usual, very interesting. So, again, I'm hoping for our future cooperation. Thank you so much.
Yes, of course. Thank you. Thank you. You're welcome.
Now, I want to ask if Professor Vivian Lopez Nunes is here with us.
Yes, hello to everybody.
Hello, hola.
I'm here.
Hello, nice to see you.
Hello, everybody. I'm Vivian Lopez. I'm from Paraguay. I'm a judge, more than a professor. I'm very honored to be in this panel and to tell about my experience as a judge, the first digital judge in my country. So I will try to be very short presentation because the time. And if you allow me to share my presentation. I think you can see it. You can see it?
Sí, perfecto.
Yes, perfect.
Thank you, Pablo. I'm also sorry because I don't speak any Russian, and so I'll try to be very clear in English. Sorry. So, well, as I said, I was the first digital judge in Paraguay. And for those who are very far away, Paraguay is a middle country in the middle of South America, like a heart of South America, next to Argentina and Brazil, in between. In 2016, we started the digitalization of the courts here. And in Asunción, where I live and where I'm a judge, it starts the electronic, the court's electronic files. And in that time, there were only one court, my court, and nobody else. No other judge, no other court were digital. It was like a pilot program. The pandemic, COVID-19, was the huge impulse for us. And after 2020, we go to all the country. So you can see all the blue in my country now is digital. More than 500 courts now, all digital, no paper anymore. For us in Paraguay, this is a huge progress, and this is very challenging because we are a developed country. In some places, we even don't have any communications like roads, but we already have electronic files in faraway courts. This picture is 2016. I was very young, not like today. And this lady in white was the president of the Supreme Court. It was our press conference for the first, the day before we start. And everybody was very like, this is not going to work. Paraguay is very poor. We don't have good internet. You're telling me stories, please. They was like, this is going to be like a pilot and it won't progress like we did. This is interview on TV, and I start to go to all newspapers, TV, social media, and everybody was very curious about this pilot, because justice in Paraguay, as I think almost everywhere, it doesn't have the acceptance of the people. We have a very bad image in Paraguay. So this was the first thing that it works, and it was good. Also, like Pablo, I did a book. It was the first manual for people, so how to use it. And this was my book, and now I'm working on the third edition. I would like to share you some numbers about the reconciliation of family and work. Most people, when we ask, and your family lives with the technology, how help you to work? And 69%, almost 70%, say that technology helps to be more at home, like the pandemic. We all live that, and you can share more time with your family, with your sons, with your daughters, with your husband, and with your parents than before the use of technology. This is to show that how technology can help to be more human in our lives before we didn't use it. And also, like I told you, in the first days, people don't want to use technology at courts. They were need the paper, need the files, need to see the judge. And now 88% thinks that the electronic files are very useful. And only 10% of the lawyers, of the people, think that is not a little useful. And none, you see, no percent, almost. Also, I did Twitter or X now. I cannot get used to that new name. About how do you feel about the electronic funds. So transparency is 48%. And what is transparency for us in Spanish? It's let me see. It's like when you provide clear understanding of where the process is. And I think transparency is the more important thing with this technology at courts, because it helps accountability. Also, backlog. 23% thinks that you can fight backlog with technology. I think yes, but not only with technology. I think AI will be the big helper for that. We're not using yet that here because we don't have that technology. Because money, right? Because money, and our Supreme Court still is very like a bit afraid of AI, and I think not. I think we should start using like Brazil is using already. Security, 14%. I think it will be higher in the next years. And not benefit at all, only 15%. I think these numbers are very important to show you, not only Russia, of the world, like how Paraguay feels about technology at courts. And to leave you something, I would like Elisabetta to share with you my best practices, what I learned about to be a digital judge. The first thing I learned that imagination and creativity are very important. And we need to create solutions. As a lawyer or as a judge, you create every day a solution to solve a case. So we need to use that imagination we have as a human to provide solutions to the problems. Something is very important is to remember that not to make a specific case, a problem we have in a specific case as a rule. Every rule has an exception. So let's use our imagination, our creativity, and our knowledge to avoid to make an exception a rule. Second, let us apply the principle of functional equivalence. If we don't know how to solve a situation now, because we don't have a manual, we study like Pablo in the university with books, we don't have technology when we study, right? So how can we solve everyday's problem? We use this principle. How will be able to solve that problem in the past without technology? We think and we use that thinking and this principle to have a solution of that particular problem. Let's train ourselves, but not only ourselves. Let's train others. Let's train our family, our colleagues. Let's train the community. Let's not keep the knowledge to ourselves. Let's be a multiplying factor and be messengers of the new era and this new change. Let's use, number 4, let's use technology for our work. Let's not close and be, no, I already learned this and don't want to learn anymore. Like in the school, the old teacher says, books do not buy. Well, technology neither. So let's use technology. We start to using WhatsApp to work. Now it's like a very useful tool, and Telegram too. Well, all technology we can learn, we have to use it. And 5, let's read. Let me show you a piece of technology that has been around for centuries, since Gutenberg, right? And it's the book. This is a technology, I think it will last for 500 and more years in the future. And don't be conservative. Don't think, I already learned everything. And I want to show this, to share this book with you, Online Courts and the Future of Justice of Richard Susskind. That is very, for me, it's like my Bible to adapt to this change. And what I learned from this book, are courts a place or a service? Do we need to go to the court to access to justice? Well, during COVID-19, we experienced there wasn't really necessary to go to courts. Virtual hearings taught us that it wasn't that necessary. So let's open our mind and let's try to be, like Euripides said, crises, however, are frightening, are useful to close an era and to start a new one. So thank you very much, Elisaveta, for this opportunity. And I don't know if it's right, spasiba. And I leave you here all my social media or WhatsApp, Telegram, if you need something more, and send you the presentation. Thank you.
Dear Vivian, I can't express by words how amazing it was. Amazing, intelligent, and very emotional. Thank you so much. All I have to say, we need, we of course need to cooperate, and, we need a separate panel to discuss all your amazing experience. Thank you so much, and I really hope we will cooperate further. Thank you. And dear Professor Van Rosalili, are you here with us?
Yes, I'm here.
Dear Professor Rosalili, I'm so sorry for this inconvenience.
No worries.
I know how precious your time, so my sincere apologies, and I will try my best, how to...
No, it's okay.
Thank you so much. Okay, thank you.
All right, let me share my screen. Okay. Okay. Can everybody see my screen? All right, great. So hello, everyone. It has been such an amazing opportunity to listen to all of you today. I am Lily. I am from the University of Bradford, and today I am going to share with you on the emergent deployment of AI in violent extremism. Maybe it is something outside from what we have been discussing since earlier. So let's just start. So let me do this. I can't see. All right. So we have been looking at how AI and the use of technology has been changing our lives, everyday lives, and it is also helped fuel radicalization and violent extremism because of the change of environment from the real world to cyberspace. We can see how our life has changed. These violent extremists or terrorists, or what we call them cyber terrorists, are also changing the way that they are communicating, the way they are carrying out their activities. So we have seen a lot of research on the terrorist use of the internet, how they are utilizing social media. And now we are looking at how they are picking and using these new emerging technologies such as artificial intelligence in committing their extremist activities. So today, basically, I am going to focus on the duality impact, where we see AI as a double-edged sword. It serves a nation's cybersecurity strategy, but at the same time, it aids terrorists to fulfill their radical goals. So First and foremost, we must understand what is violent extremism. It is very diverse. There's no specific definition on what is violent extremism. However, it is usually shaped by a terrorist organization. It is never exclusive to any religion, nationality, or any system of belief. And it has somewhat evolved from what we see in the 9/11 war on terror, where during that time, the response were more focused, where they are looking into coercive measures through hard military actions. And now we can see how it has moved to more non-coercive approach, where these nations or these organizations are more focused on counter-narrative, capacity building, community engagement, and empowerment education. So in the terrorist use of internet, we can see due to the shift of environment, now everything is online, as we have been discussing since all of the speakers have already discussed. There is a change of environment. And because of the nature or environment of the cyberspace itself, it is seamless, it is transborder, there's no border control, when usually any terrorist attacks or any terrorist activities are usually planned on the ground, means they have to go to certain locations, but with everything online, it is done more seamlessly. And because also the lure of anonymity and also the use of social media platform and encrypted communication application, and these environment and these situation provide a safe haven for these terrorists. In terms of the criminal justice context, we can see how AI itself or these emerging technologies has helped in facilitating investigation, facial recognition, sentencing, parole, and we can also look into predictive of future criminal behavior, recidivism. In terms of cybersecurity, we're looking at how a lot of nations are focusing on the use of AI specifically in terms of moderating contents within the social media or within the internet itself, and they are more focused on the preemptive approach through prediction capability. However, when we see these nations are very much excited to use these type of new technologies, and we see AI as something that helps us facilitate our daily lives or facilitate or makes our life easier in certain sectors, sometimes it is overlooked how these terrorists are also utilizing, adopting these type of technologies in conducting their activities. And they will use this type of technology to avoid being detected. So they will use this latest technological development to increase visibility undetected. And now we can see how research have gone into how there is grooming by chatbots, where these people are radicalized by chatbots, and there are also issues on ChatGPT. We have looked into a lot of news that highlight there are ideas or ideology or narratives that has that exists within ChatGPT, which would then push for lone wolf terrorists to conduct their terrorist attacks individually. So what these people would do is they use this technology to modify terms and the content online to avoid AI detection. They distort videos, pixel the image and videos to avoid detection. They use drone swarming, they use autonomous vehicle, and they use the natural language processing, where they will make content that is available online to be, it looks as it is original content. So it makes people more easier to be radicalized. So the challenge that we have now as a nation, from various jurisdictions, and this is a worldwide problem, is as highlighted by some esteemed speaker which has spoken before me, is the absence of specific an agreed common definition, and in this case is on online radicalization and extremism. And because of the absence of this specific definition, it is more challenging to regulate these type of acts and behaviors. And the verification of data sets collection in the detection and prediction, which always leads to issues of biasness and prejudice. And the lack of operations across research fields means that people are developing technologies, but they are not checking the challenges that certain sectors are having. So it is done based not on existing theories. And that's why we have instances where ChatGPT or any other, types of new technology, which was actually invented to make our life easier. But at the same time, it has been helping in recruitment, attracting sympathizers, and the radicalization process of an individual. And also the constant evolution of the behavior to avoid detection by current algorithm. So in terms of how nations are trying to detect extremist content, but at the same time, they are countering it by changing terminologies. They're creating new accounts and channels, and also the ever-changing narratives. So sometimes the technology is looking for certain keywords, but now they have changed it, and it becomes a cycle. And the development of ethics and legislation in countering VE itself, there is a hesitancy to regulate due to issues of transparency, trustworthiness, privacy and data protection, and all of the things that have been highlighted by Dr. Huma earlier on in terms of in regulating such things. So in the way forward is basically to implement government-led AI safety framework. It is also to put in effective safety brakes for AI system that control critical infrastructure. When the questions, and I know this question will come into place every time when we talk about, when we give these type of technologies all of the freedom, how do we control it if it gets too powerful? How do we put on the safety brakes? And to develop a legal and regulatory framework for an AI. So everything is done now. Now it's currently in place. So we are looking forward to looking at how international organizations and countries are managing this, and know the content, a way to manage misinformation, and lastly, in applying and enforcing existing laws and create
Dear Professor Rosalili, thank you. Yeah. I'm so sorry, but we are really lack of time.
Yeah, I'm finished.
Can you please? Yes, thank you. I'm so sorry for that. Could you please? Yes, yeah. Thank you so much.
Yeah, thank you.
Thank you. Да, если бы. Да, мы сейчас поедем. Thank you so much. Do we have participants from Cuba?
Yes.
Could you please be brief, very, very brief? I'm so sorry, but we have to leave the room. So you have like 5 minutes, please. I am so much sorry for that.
Okay, thank you. Can you hear me?
Yes, perfect.
Easy. Perfect, thank you. Okay, before I start, I would like to express my thanks and my gratitude on behalf of the University of Sancti Spiritus in Cuba, to the University of Kazan, for giving us the opportunity of participating in one of the most important conferences about law and technology. Secondly, I would like to thank all the scientific community that are present here today for all their efforts of making the best advancement in science and technology. Now, without any further ado, I would like to start the presentation. My name is Sohan Mahmoud. I'm a fourth-year student of computer science engineering in the University of Santo Espiritu in Cuba. I'm here presenting the work of a vulnerability detection tool, a web scanner that scans a website given its URL. This work is co-authored by my tutors, which are a PhD and cybersecurity specialist, Dr. Carlos Lázaro Jiménez Puerto, and Master in Science, Julio Compagnoni Martinez. Now, every day, our lives depend more and more on the digital world, the microtransactions, the online purchasing and payments. The social media has made our lives a lot easier in so many ways, but at the same time has exposed all our personal information to the world and made it very easy to access. So that being said, it's something of a high priority to have a better protection for our personal information so it doesn't get stolen and it doesn't get into the wrong hands. On an international scale, cybersecurity is one of the most important pillars to all the organizations, universities, and institutions. So much so that it became a mandatory thing to implement their own protection systems or make use of the existing ones, so they can guarantee a higher protection to the information and data, whether it was work-related information or it was personal or professional employees' information. Before I get to the web scanner, I would like and its functions, I would like to make some emphasis on some of these cybersecurity attacks we're going to be treated in this project. Some of them are the social engineering and the phishing attacks. Now, there are millions of ways and methods to hack a person or an entity. One of the most common method is known as social engineering, and it consists of cyber criminals, or also known as hackers, getting to know a person and finding some sort of empathy with them, making it easy to gain their trust so they can use it against them in order to steal their information and harm them in any way possible. Now, social engineering has multiple subcategories. One of the most famous subcategories is called phishing attack. It consists of sending an email or a message that contains a link to a website, most likely a famous website, but not the legitimate one. It contains a malicious software or malware that can steal and harm the victim, making it a phishing attack. The web scanner tools, the web scanner can, as we said before, can scan a website given its URL, and it can perform the following scans. Getting the IP address, as we all know, an IP address is an internet protocol address. Essentially, it is a numeric value assigned to a network device, and it's used for identification and location. A domain name, which is a string of text that maps an alphanumeric IP address used to access a website client from a software, or in other words, a domain name is the text that a user types into a browser window to reach a particular website. It can perform an Nmap scan. Nmap is short for network mapper. It is a free open source tool used for vulnerability checking, port scanning, and of course network mapping. Perform a Whois scan, which is the most important one. A Whois scan is a type of network reconnaissance that involves querying into a Whois database to obtain information about a domain name or an IP address. The Whois database contains information about the ownership and administrative contacts for a particular domain name or an IP address, as well as other details such as registration and expiration dates. It can also get the robots.txt file. The robots.txt file, as the name indicates, is a file that is placed in the root directory of every website to provide instruction on a web robot, or also known as web crawlers or spiders, on how to crawl on an index a website page. The robots.txt file is not not all websites have it on them. With those functions, we can safely say that the web scanner is a tool very helpful to identify all type of phishing emails. As a conclusion, cybersecurity nowadays is one of the most important subjects around the world, since all the information, whether it was personal, professional, or work-related, is online, and the need of security system to prevent the loss of said information is something of a highly important and necessary. The web scanner is a tool used to prevent phishing attacks victims to fall into the trap, which makes it a very necessary and important tool for every institution, organization, or university. With the help of the web scanner, it is predicted to decrease the number of victims of social engineering phishing attacks in the University of St. Louis. Thank you very much for your time.
Thank you so much for your brief but very interesting keynote. Bye-bye to everyone. Thank you so much again, dear participants.
Thank you.
Thank you.